Welcome.
Wonderful.
Thank you very much to be connected with us. We are all listening to you. We are all very impatient to hear what you have to tell about GDPR and this enforcement, which is very difficult in the day-to-day life.
Thanks a lot for the invitation, and sorry I can't be there for logistical reasons, so to say. So I was asked to talk a bit about privacy as an intro, and I think to probably start off, I usually try to explain a bit that privacy has like two dimensions usually. The one thing is this kind of feeling of surveillance, which is quite well understood with like the idea of a panopticon, which you see right now. So in this case, a prison where there's a prison guard in the middle, and they can theoretically watch everybody, but obviously only one person is watched at a time, but everybody feels surveilled. So I think it's oftentimes useful for privacy to think about this emotional part of privacy that may not be that logical in each case, because in a logical world, you can understand that only a small percentage of people will actually be watched, but people still have the feeling to be watched. There are other types of privacy. A good example is kind of privacy in the voting booth, where it's very logical that if your employer knows who you're voting for, your partner knows, that may limit your freedom in this moment, and it's kind of more understandable maybe for people why there's privacy in these situations. And that also makes like pictures like that funny in the sense that if your partner looks over and is not sure, you may not have all that much of a freedom. Um, Another good example of privacy that may not be logical is typically sexuality and emotions. That is oftentimes something that people feel is very private, but for not necessarily any logical reason, somehow embedded in our in the human brain that this is a private matter, which, for example, for most animals, it's not. And I think that's also a nice example of these different dimensions of privacy. Now, what's interesting is we can probably go into that much longer, but what's interesting is now with the kind of internet and the world growing together, there are different views, also different cultural views collide there. And there are even different dimensions of privacy that are seen as more or less private per culture. So it's not just that, cultures care more or less about privacy. It's also the different dimensions are more or less private. A good example for that, usually in Austria, you don't talk about personal finances, even with your friends. It's seen as a private matter. At the same time, for example, sexuality or relationship stuff is maybe more talked about than, for example, with American friends of mine. So I think it's also interesting to think about that there's just a lot of cultural background here. Um, all of that kind of became for us a bit more apparent, or for the broader public, when Snowden made its disclosures, which I sometimes call like the Chernobyl of privacy. It's like kind of a bit the point where no one could ignore that there are some issues, and we have to somehow talk about them. That all got us to the EU-US data transfer debate, and I would like to start off with like the US side of surveillance to quickly explain how these surveillance laws in the US look like. What I'm going to present now is a very, very simplified version, because doing like the details would probably take a whole day. But the background was basically of this case was basically the demonstrations we had after the Snowden disclosures. And the idea was, as we now know how surveillance roughly looks in the US, if we can actually bring a case around that. What I have to stress is these slides are now about 10 years old, or partly even older. And not just judging from the design of these slides, you can probably assume that a lot of the technology has evolved since then. And there may be new surveillance programs in the US that we've just not heard about or don't know about because there is no disclosures on them yet. But what we do know is that there's basically the idea of upstream surveillance, which is capturing data on the backbone of the internet, and then PRISM, now downstream surveillance, where the idea is to capture the data right from the companies that hold the data, especially because there is easier access because of lack of encryption there. Most of that is done under FISA 702. It's also US 50 Court 1881A. It has two numbers. And the law in the US is kind of unique in the sense that it says you can have a so-called electronic communication service provider, which is basically all your cloud companies, telecom companies, and so on. And that company must hold what they call foreign intelligence information. And that's a very, very broad term that includes, for example, anything that is relevant for the foreign conduct of the United States. So basically espionage. All of that is approved by a court in a certification for 1 year. So what's important to understand is this court does not approve individual surveillance. It approves the whole surveillance system for 1 year. So PRISM or Upstream is approved that way. It doesn't say, there is an approval for an individual company to have data caught from that company, or even an individual person or individual topic. It's really the whole surveillance program is approved. What's the biggest part or the most important part is that there are so-called minimization and targeting procedures that are basically meant to filter out Americans, because all of that would be a violation of the Fourth Amendment in the US. Surveillance to that extreme, in these extreme ways without a judicial approval will interestingly be illegal on both sides of the Atlantic. Just that under the US doctrine, only US persons are covered under the Fourth Amendment. And therefore, you solve the problem by simply filtering that out, and foreigners don't have these rights anyway, so you can go ahead. What you then have is a so-called directive to the individual service provider, which is kind of the order to open something like an API. That exact type of how the data is collected and shared is not in the law, so we can just assume it's an API from the evidence that's around it. In our case, I was basically this little Austrian smiley down here, and I had a contract with Facebook Ireland at the time, and they forwarded most of the data to Facebook in the US. And the data was basically captured once on the upstream level and then again via PRISM. Both of that is done under this law that I just mentioned. And then there is also a so-called Executive Order 12333, which also allows upstream surveillance. And there is, or used to be, PPD 28, which kind of limits all of that. So it's a bit of a complicated environment where multiple instruments overlay, and you have to kind of find your way through it as a lawyer. What was really interesting is that, especially from a technical perspective, the really interesting part is with PRISM, as I said, that usually these companies have to hold the keys, or it's not even encrypted at certain parts on the PRISM side of this equation, which makes it much easier for them to actually capture the data there. Now that's kind of the US side. On the European side, we have the following situation. Generally, the GDPR, but also the data protection laws we had ever since 1995 prohibit the export of personal data. So we basically have an export prohibition in Europe. And there are derogations for what you call necessary transfers, which is basically if you have to send an email abroad, if you have to book something abroad, the stuff that is really necessary. But we actually see that most of the data transfers that happen are not necessary, but more outsourcing. And for these situations, there's also rules, and that's also possible under the law, but in very limited circumstances. And they basically, these rules expand the GDPR rules to non-EU countries. So in very simple ways, the European Union says, if you follow the European law, even if you're not in Europe, then you can have our data. If not, then not. So you basically expand these GDPR rules to third countries. Now, this works really well. For example, if you have a country like Switzerland that has more or less a data protection act that's very similar than the European Union, then you basically say, okay, we're all part of this kind of privacy bubble and you can have free data flows, all good, all fine. It can also work with a country like the US if there's no data protection act. So in the US, there's no general omnibus privacy law, and there's more or less a vacuum. And that vacuum you can fill with a contract. You can basically, as a company, say, there's a vacuum, I'm just gonna opt into a higher rule, sign a contract that I'll follow these rules. And that is kind of what these SSCs, Privacy Shield, BCRs, all these different instruments are. They're a contractual measure so that a foreign entity follows European law and signs a contract to do so. And that theoretically also makes sense. The big problem in the US is that there's not just a vacuum, but there is FISA that actually requires this company not to provide full privacy. So in very simple terms, we have a situation where one side of the Atlantic requires privacy, the other side requires surveillance, and the companies are somehow in between and can hardly follow both of these rules at the same time. And that is where these contracts that are signed are, after all, simply void because you are not allowed to follow these contracts under American law. And that is fundamentally what this whole case is about, or this whole conflict is about. And that is also the reason why we cannot easily solve it, because it's mainly a political conflict of law situation, where usually as NOIP we kind of say, you know, you gotta change these buttons or do this technology and get away with it. But in this case, it's more of a political problem. So we have current case law now from the Court of Justice. Basically, they say that the American surveillance systems do not just interfere with what we call proportionality in Europe. So usually we balance the right to privacy and other interests and try to kind of find an approach to say, okay, it's a interference with your privacy, but it's a proportionate interference because of some public interest, or it is not proportionate anymore. And that's usually a bit of a sliding scale. However, there's the possibility that you also have a violation of the essence of a fundamental right. That means the violation is so massive that you don't even have to engage in a proportionality test. Usually, most of these surveillance measures, also in Europe, like data retention, for example, the Court of Justice found to be not proportionate. The American approach they called even a violation of the essence of your fundamental right. And that is interesting because that never happened in any other cases so far. So the Court of Justice is very strong on the American surveillance laws there. So right now, to do data transfers, you have to first of all make sure that you ensure that in another country there is essential equivalence to the GDPR. So you have to make sure that the privacy level is about what the GDPR would provide for. But you also have to be compliant with the Charter of Fundamental Rights. And that is your right to privacy, your right to data protection, and 47 is your right to judicial redress. So you have to have the option to also enforce these rights in a foreign jurisdiction. Now, what the European Commission did with all of that is that they basically now have the third deal in the making, despite what the Court of Justice said. And what the European Commission does with that is it's very much a PR effort. So, for example, if we had the second deal, which was the Privacy Shield, we got this wonderful logo you see here, and the Commission said, you know, there's a deal. But when an American NGO made a Freedom of Information request to actually get a copy of this deal that was announced, the answer was that the copy cannot be given because the record that you requested does not exist. So they presented the deal without having the text of the deal yet, and only 2 months later they actually came up with the text. And the text was very much the same as the safe harbor deal that was already struck down before. So we see a certain pattern of just passing a deal over and over and over again, even if you know that it's not really legal what you're doing. A very simple example how the tactics behind that work is this quote from a press release of the European Commission back for the Privacy Shield. And they said the US authorities assured that there is no indiscriminate or mass surveillance by national security authorities. And that sounds nice, but if you think about it, it just says that the Americans have assured that there is nothing. It doesn't say that there is nothing. It just said that the Americans claimed there is nothing. And that's a bit like asking the Chinese about like fundamental rights in China. You will hardly get a statement by the Chinese government saying, yeah, we're really bad. And that is a bit how stuff like that was outsourced. The other thing that's interesting here is indiscriminate or mass surveillance. That's what the Americans call mass surveillance may be different than what we call mass surveillance. And if you then dig into the actual decision, there's an annex to this whole thing. They actually, in the European Commission decision, already say that there's collection in bulk for 6 different purposes, including, for example, combating transnational criminal threats. So just the possibility of a crime that could go across a border. You don't need a crime yet. You just need the threat of a crime. Is already enough to do bulk surveillance. Now, the press release says no indiscriminate or mass surveillance. The thing itself says bulk surveillance. You can all guess what the difference is. It's basically none. And it's interesting if you have press releases that kind of go right against the text of the thing you're just deciding. If you then dig even a bit deeper on the American side of it, you find that this word bulk surveillance has a footnote. And that footnote actually says that they don't call it bulk surveillance if they capture all the data to then find, so to say, the needle in the haystack. They only call it bulk surveillance if the whole haystack is constantly monitored. So if you dig into it, you get very far away from these press releases, and you realize that under the hood there is just a very different situation than what the public is told in these situations. Another good one was that the Privacy Shield basically introduced a so-called ombudsperson. So instead of having a court, the idea was you can go to an ombudsperson, and it worked like that you would go to your National Data Protection Authority. They would then raise an issue with the ombudsperson. That was the ombudsperson at the time. They would kind of figure out stuff out within the US. We don't know what they would do and how exactly this would work. And you would always get a very specific answer that the case has been investigated and the US either complied or remedied the situation. And they will neither confirm nor deny that there was any surveillance anyways. So no matter what your situation was, you would always get this answer. If you were under surveillance, you get this answer. If you were not under surveillance, you get this answer. If you complied with the law, you got this answer. If you didn't comply with the law, you got that answer. So it's basically not what we would call a court. It's more of a kind of rubber stamp situation. The outcome of that for practical consequences of this litigation, that it was struck down twice, is the following: that we basically have to look at the outsourcing part here, the second one. And that is where you have fundamental problems when you outsource to the US right now. To kind of probably split up the situation a bit, because not everything that goes to the US is illegal. You can split it up. For example, if you have a flight or you send an email or you book a hotel, that is what you would usually call a necessary transfer under Article 49 of the GDPR. So this kind of drama that you're not going to be able to send emails to the US anymore is just not true. However, if you outsource to a so-called FISA company, so an electronic communication service provider, you have a massive problem. The same thing is also true if the server is in Europe. So a lot of the American companies said, oh, no, don't worry, our server is in Europe. The reality of FISA is it applies to servers worldwide as long as the American company has what they call possession, custody, control. So if, let's say, there's a subsidiary in Europe where the Americans don't have access to that data, but just hold the shares, for example, that could be a solution where data could be held in Europe and be safe. However, if basically it's part of a larger global network and you can access the data from the US, they have to provide the data under US law. There may, however, also be the situation that you have a normal company in the US. So let's say you're an airline and you have your local subsidiary in the US. You may not fall under the electronic communication service provider definition and therefore not fall under FISA. So you may have situations where you send data back and forth to the US where there's actually no mass surveillance law that applies to it. And that makes the whole thing a bit tricky. Like you have to really differentiate between these cases. We then filed 101 complaints. So we basically went through just websites trying to figure out who uses Google Analytics and Facebook Pixel. Just randomly, more or less, we chose these two. And when we went through the top level domains of the European Union and found larger pages that used that, we ended up with 101 of these complaints, which gave us the kind of 100 all Dalmatians theme to the whole thing. What was interesting is were the main arguments that the companies right now use to still transfer data to the US. The first thing we got is sorry, removed it. So they basically said, okay, let's just try until someone complains. The second thing that is now used is what they call supplementary measures. I'm going to get into that in a second. And then there is the so-called what they call risk-based approach, which I'll get to as well. Now, the idea of the supplementary measures is that even if the law fails, we may have a technical solution that could protect your data. The idea of the supplementary measures could be, for example, that there's encryption backups, or more or less zero knowledge approaches. again, that gets down to the idea that if an American company says, we don't have that data, we can't access it, then they don't have to provide it under American law. However, we all know that there is very limited applications where this could actually work. So for example, if you say data just passes through the US and then goes to some recipient abroad, that may be something where the encryption in transit could work, and you have an end-to-end encryption, and therefore you don't have to worry too much what happens in between. But that's not really how it could work for like American recipients usually. There is also the idea of contractual supplementary measures. So, for example, that you have to inform the sender that data was disclosed to U.S. authorities, or that they have to kind of resist if the U.S. Approaches. However, all of that conflicts with the law of the U.S., so it doesn't really get you anywhere because they're not allowed to inform you. They're not allowed to kind of do any specific resistance. So there's not really any option that helps you there. We looked into the supplementary measures of Facebook. If anybody really wants to fall asleep, there's even videos of me reading them out. And they more or less say that, they have teams that review stuff, and they do have SSL encryption and all stuff that really doesn't make any difference, but it produces tons of pages. Google was kind of funny. They even had like one of their supplementary measures was that they have a fence around their data center and signs saying that you shouldn't enter it. Not sure if that impresses the NSA, but that's kind of how Google thinks that they can solve the problem. By now, we had a couple of DPAs. We just had the Hungarian DPA this week to also join the club that say that basically for these reasons, you can transfer data to the US. And that is right now the state of the law. The other thing that came up was the so-called risk-based approach. So some lawyers had the wonderful idea that because some elements of the GDPR use the word risk, they just said, oh, that's a general principle of the GDPR, and therefore we just say that there is a risk-based approach for data transfers, and therefore we just assume that there is no risk. That was already before the Austrian authority, for example, and was rejected as well. So there's not really much of a solution there. Now, politics got involved again this spring, and they now came up with a new solution, which is going to be again the old privacy shield, but with an additional layer on top of it, which they call the EU-US framework. Now, all of that was based on a meeting between von der Leyen and Biden after the invasion in Ukraine, and it was apparently a lot of pressure to say now we have to stand together and show that we're friends, and therefore we need data transfers. I don't personally understand the logic between the two things, but apparently in political logic it exists. The announcement basically has a couple of things. They basically say that Privacy Shield stays as it is. There's no changes to the underlying system, but there's going to be an executive order that will introduce what they call proportionate and necessary in the US. I'll get into that in a second. And there will be a so-called data protection court. That's basically it. An executive order, just to give you an idea, is an internal order of the president. So we all remember Trump with his Sharpies. That is basically him telling people below him to do something or not do something. It is not a law. It is more of an internal order, just like within a company, if the boss says, please do A or B, it doesn't allow third parties to enforce that usually. Same thing in the US. You cannot kind of sue because some official didn't follow an executive order. And what's interesting now is they added basically two elements. The first element is that they say US surveillance has to be proportionate. Now, the Court of Justice already found that PRISM, for example, is not proportionate. So it's kind of amazing that this executive order now says it is proportionate. And there's basically two ways. First of all, they could stop PRISM and upstream because of the lack of proportionality. The US has already said that's not what they're doing. The other option is that they apply not a European standard of proportionality, but that they come up with its own standard. And that is what they did. The side documents already say that there is an American understanding of these wordings, and that will basically mean that we'll just shift proportionality to almost nowhere to come up to the conclusion that actually under a US understanding of the word proportionality, we're on the green zone. And that is basically what we now see as a solution here, is that basically politically we agreed on both sides to just have a different understanding of the word proportionality. The other thing that they did now is that they changed the ombudsperson to a CLPO. Everything else stays the same. The only difference is that it's now within the Justice Ministry and they can actually um, order within the US authorities to do things and not to do things. And then they added a so-called data protection court. It is literally a copy of the system of the ombudsperson with the same answer that you get in any case, just that now there's a couple of people making these decisions that are more independent. But the answer you'll get is still going to be exactly the same. You're not going to be able to actually be before this court. You're not going to be able to actually be represented by anybody. There is basically a representative that the US itself chooses that is meant to kind of represent the people there. But you will always get the same standard answer and you will not know what actually happened to your case. We even like now produced a stamp that gives you exactly the answer you'll get, and no matter what this court will do, you always get the lines that you see right now and basically say that there is no confirmation or denial that there was any kind of surveillance and that either the review did not identify any kind of violation or they did actually do some changes, but you're not allowed to know what they were. So after all, you don't even know if your case was actually treated. Finally, just a short side notice, there's also the problem with commercial data usage in the US. The Privacy Shield still follows a system from 2000, more or less, and is not following the GDPR system. So for example, instead of consent or one of the other legal bases, you have opt-out in the US. Instead of like full access to your data, you have very limited access. Instead of data having to be necessary for the purpose that you have, it only has to be relevant under the US system. And there's a lot of other differences like that where we also have to wonder if that's actually the same. Finally, the way forward. So how could we actually solve the surveillance issue? And I think I also want to highlight that we also have European member states where there's similar surveillance. So it's not just an American problem. For very technical legal reasons, we cannot necessarily go after EU member states, but we can go after non-EU member states. A whole different story why it doesn't make much sense, but that's just the way it is. I think basically what we need forward. Just gonna jump back. I thought I'm gonna be 2 slides later. So what's the way forward for this specific deal? That's kind of what I wanted to say. It's basically gonna go back to the Court of Justice. The timeline is gonna be more or less like the following. In October, we now got the executive order. There's gonna be a draft Privacy Shield decision by the Commission beginning of next year. Then there's gonna be final Privacy Shield decision because there is the European Data Protection Board and the member states that can actually make comments on it. And then we're planning to challenge that rather quickly. And we'll probably have another 1.5 to 2 years until we actually have a decision on all of this again. So we're basically going to be back in a ping pong, and now to get to kind of the idea how we can solve that. I think in the long run, we need a political solution for all of this. And what we need is that at least among democratic countries, did we agree that your right to privacy should not depend on your citizenship? Because on the internet, you're usually not the citizen most places and most websites you visit, or most services you use. So the idea is to have a level playing field. What you would need for that is what you would call a so-called no spy agreement. So an agreement between at least the democratic countries that we follow the basic rules that we all kind of use within our countries anyways. That's usually that you need probable cause for surveillance and that you need a judge approving it. That is more or less something we agree throughout the democratic countries, and that would be making a lot of sense to kind of have a global internet still, to agree that we give these rights to each other. Right now, the biggest problem in all of that is basically US Congress. Whenever you talk to anybody in the US, they say, oh, we understand that our kind of foreign customers would like to have some rights, but within the US political system, it's very hard to get anything like that done. So I'm kind of interested if that's going to move or if that's going to change, but right now that seems to be the biggest issue here, that would need changes in the law in the US. And right now it's very hard to even change very basic laws in the US, let alone rights for foreigners. I hope that was useful for you all, and thank you for listening in. And we're going to be right in the debate now anyways. Thanks a lot.
Thanks a lot. Thanks a lot, Max. We'll keep you with us 20 minutes more because I would like you to discuss with Tariq Rim. Tariq Rim, please welcome Tariq Rim.